Good morning, Mr. President. My name is Ramesh Kanna and I act for the appellant, Mr. Antonio Fortuna. I will bring you through the first two issues for 10 minutes, followed by my co-counsel, Mr. Brandon Zhang, who will
Mm.
bring you through the last two issues for 10 minutes. And we respectfully reserve 1 minute for our rebuttals. Now,
Go on.
Mr.
Can you
President,
give me the brief facts of the case first, very quickly? Why we are here?
so the facts, simply put, is the player, Antonio Fortuna, has been accused of participating in match manipulation. And the first issue is whether his statement of appeal can be admissible given that the statement of appeal was admitted late. And the second issue is um, whether his refusal to hand over his phone when he was asked for an investigation was lawful. And the third issue is whether certain pieces of anonymous evidence are admissible against Mr. Fortuna.
Mm.
So the respondent will be arguing that they are admissible. And the last issue is whether Mr. Fortuna had indeed committed match manipulation with according to Article 20 of the FIFA Disciplinary Code.
Mm.
This would be the facts in. Would
Okay, go on.
Mr. President have any further questions regarding the facts?
I'm quite comfortable with that. Counsel, please proceed. Would you introduce yourself and the names of you and your counsels, please, and also the name of your responding counsels, please?
Okay. Respondent counsel would be Ramesh Khanna, who will bring you through the first two issues, and his co-counsel, Mr. Austin Seah, who will bring you the last two issues. And they too respectfully reserve 1 minute for rebuttals with 10 minutes for their main submissions each.
All right. I'm obliged. Continue.
Okay. Mr. President, the case that confronts you today requires you to take a stance on this sliding scale between procedural fairness and substantive justice. Now, the appellant acknowledges that in the vast majority of cases, the position to be taken is already concretized in both the CAS Code and the FIFA Disciplinary Code. However, this balance shifts in cases with exceptional circumstances. And our argument today is that the case before us does fall within one such exception. Now, with this regard, I make two submissions. Firstly, the statement of appeal is admissible via the remedy of reinstatement. And secondly, Mr. Fortuna's refusal to hand over his phone was not unlawful. Now, with regard to my first submission, the appellant concedes that indeed the statement of appeal was not sent in within the requisite time. Now, the deadline for the statement of appeal, as per Article 50, subsection 1 of the FIFA Code, is 21 days after the receipt of the decision. Now, when we talk about decision, as per Article 50, subsection 1, it's referring to decision with full grounds.
Mm.
Thus, the decision with full grounds was only received on the 2nd of March. Therefore, the 21-day window period ends on the 23rd of April. Now, as per the facts, the filing of the statement of appeal was attempted within this deadline indeed. However, it was not received because as per R31 of the CAS Code, electronic filings are admitted or considered admitted only upon receipt by the CAS office. Now, on the facts, the issue is that due to a system error in place on the appellant's cyber systems, the statement of appeal never reached the CAS office, that is within the sphere of control of the recipient. Thus, we do agree that the statement of appeal has not been filed. Now, opposing counsel may rely on cases such as the 2016 Swiss Federal Tribunal case of claimant and FIFA to state that the principle of equal treatment and in interest of legal certainty, extra time should not be accorded to the appellant. However, even this particular case does not set an absolute stance in that no exceptions should be made. It still left room for exceptions. And this has been interpreted in a line of cases that came after it, such as the 2019 CAS decision of PFC and UEFA, and the 2024 decision, a very recent one, in this panel, by FC Football Club and Galatasaray AS. What both these cases state is that reinstatement should be allowed if two particular conditions are met. One, the first condition is that the failure to meet the deadline must have been due to no fault of the appellant. And secondly, the request for reinstatement must have been prompt. Now, the principle for the no fault requirement centers around foresight. That is, whether the incidence of disorder was foreseeable such that the appellant is at fault for not taking preventive measures. Thus, we do acknowledge that the threshold is a high one. It's not just about whether the appellant was the cause of the instance of disorder, but if it was foreseeable, they must have taken measures to prevent it as well. And in this case, we would say that the Christina Iowa cast decision is an instructive precedent to look at because that case also centered around a failed electronic filing. However, the electronic filing in that case failed due to an expired security certificate
Mm.
on the appellant's server. And thus the CAS panel ruled that the security certificate expiring was a very foreseeable occurrence that could have been prevented. Now, this is directly distinguishable from the case that confronts us today, because the cyber threat was caused by a malicious third party that was acting independently of the appellant.
Counsel, are you aware that for arbitration in sports, issues of precedent, which is common in certain nations of common law system, does not necessarily apply. Furthermore, in court of arbitration for sports, can you first advise me whether or not, for this case, the burden of proof remains with the appellant, and the standard of proof is actually, is it A, on a balance of probability, or B, comfortable satisfaction? What is the standard of proof in our case?
I understand that you have posed two questions, Mr.
Mm.
President. So firstly, with regard to the need to follow precedent, we do agree that arbitral tribunals are not held by the necessity to follow precedent. However, it's an ideal that is greatly appreciated due to legal certainty and security that is provided by it. To answer a second question with regard to what is the standard of proof, the standard of proof would be comfortable satisfaction, which is greater than a balance of probabilities, but less than the criminal standard of beyond a reasonable doubt.
So our case is on a comfortable satisfaction.
Yes.
So in the case, counsel, if it's a comfortable satisfaction, the key is whether I am going to be subjectively comfortably satisfied with the case, and therefore the issue of precedent, there is no issue of precedent then, because it's just purely persuasive for me. And I know British lawyers like to use the phrase distinguishable. Uh, Again, factually, that's irrelevant to us as an arbitrator for a matter which is on the standards of comfortable satisfaction, because all pure, everything is purely persuasive for us, and it's for me to decide whether or not I am comfortably satisfied with the case. So I would recommend you to just proceed, but perhaps just inform me where the facts differ from our case, and I will make a decision later with regards to the matter in case. Kindly proceed, counsel.
Understood, Mr. President. So, how the facts differ in our present case is that we would say the instance of disorder was not foreseeable by the appellant, and the appellant had done its utmost duty in ensuring that its cybersecurity systems were up to industry standards. This can be referred to in the clarifications page. Now, the second requirement of promptness is one that is more contentious because we do realize that the instance of disorder had already been reported off on the 26th of April. However, the request for reinstatement was only made on the 28th of April. And we are well aware that the respondent will state that this delay was undue and that it does not meet the promptness requirement. However, the remedy of reinstatement does not require immediate action. Rather,
Mm.
any delay that is taken must have reason that satisfies the panel as being reasonable. And in our present case, a law firm that acts at this scale would have had multiple issues sending various documents to all the cases that they handle, thus requiring them to take one day to sort out all the matters that are within their belt would have been considered prompt, and that is our argument because 26th of April is a Sunday and 27th of April is the first working day. Thus, any action could have only been taken on Monday, and on Tuesday, the document was sent before afternoon. As we would say that we have acted promptly.
The key is the extent of the phrase promptly here. And it's for this arbitration to decide whether you have satisfied that. Am I correct?
Yes, Mr. President. And whether
So,
we have and the decision to decide and the decision on whether we have satisfied that requirement should be made based on what reasons we provide for the delay and whether the panel is sufficiently satisfied with those reasons.
all right, move on. Next topic, next issue. I've heard enough. Next issue.
With regard to the second issue, Mr. Fortuna's refusal to hand over his phone was not unlawful because it's protected by Article 6 of the ECHR. Now, Mr. President may wonder why the ECHR is relevant, but that is because this panel is seated in Switzerland, and Switzerland is a member of this convention, and thus the convention's articles do apply. Now, Article 6's right against self-incrimination provides the appellant with the right to withhold information that would prejudice him in his parallel criminal proceedings. Now, we wish to make a distinction here. The appellant is not arguing that the appellant has a right against self-incrimination with regard to FIFA. Rather, our argument is that if he was to hand over his phone to FIFA, his rights against the public prosecutor in the Iridonian criminal proceedings would be prejudiced. And in this particular case, what is required is that there must be clear and imminent danger that there will be a sharing of information between the public prosecutor and FIFA to show that Article 6's rights can be invoked. This was seen in the 2017 decision of Jerome Valque and FIFA. Mr. President, I understand that my time has just elapsed. Could I request for 1 minute to sum up my submissions?
Yes, please. Yes. To be fair to you, I asked quite a number of questions, so I've taken up your time. Continue.
So in the case of Jerome Valque, why the clear and imminent danger threshold had not been met was because there was no collaboration or information sharing between the public prosecutor and the FIFA panel. However, in the present case, FIFA, the moment it received the anonymous evidence, immediately emailed it to the public prosecutor. And this was indeed the reason why criminal proceedings were even started against the appellant in the first place. Thus, we would argue that there's clear and imminent danger that there's going to be a sharing of information if the appellant shares the records on his phone with FIFA as well. Now, the sub-issue under here is whether an adverse inference can be made due to this refusal. And adverse inferences, as per CAST jurisprudence, require two elements to be met. Firstly, whatever evidence that has been requested must have been of probative value. And secondly, the appellant must have had control of the evidence to provide it. In this particular case, neither element is met because FIFA did not specify what evidence it required. Instead, it just gave the appellant a fishing exercise by stating that they should provide any relevant evidence. And this was in fact in the second request. The first request is just them asking absolute rights over the appellant's phone itself. Thus, since we cannot isolate what is the evidence that FIFA seeks, we can't even conduct the test of probative value. And nevertheless, even if Mr. President is convinced that there is probative value, it's not within the appellant's control to provide this evidence because of the ongoing criminal proceedings, which would prejudice his rights against self-incrimination. With that, I conclude my submissions by stating that procedural fairness in CAST jurisprudence is not formalistic and dependent on rigid rules, but rather calibrated towards the circumstances of the case. If I may be of no further assistance, I conclude my submissions.
Yeah, I think that's all right. That's enough. I'm so sorry that I have to text the phone because today is Valentine's Day. There's a delivery coming to my house. So the guy keep on texting me. I have to reply. It's supposed to be a surprise for my wife, but I think the florists have left my house. Apparently, he came to my house and left. Shite. So sorry. I don't mean to be rude by
Oh, no
looking at
worries,
my
no worries.
phone. Yeah.
Is there
It's
anything that you would like me to repeat if you have
no, no.
not
I
yet
heard
had a
you.
chance?
I heard you. It's about actually your first this first issue is really purely on time and technicality. So it's not really a sports law question. It's more towards a technical question. But you, for your information and for the three of you, in cash, right? Timing of filing very, very important. You cannot even be 1 day late. So usually when we take up cash cases, which is, to be fair, very rare. There's not many cases in Malaysia which goes there. We are very careful with our diary. Uh, okay. All yours, Brendan. Thank you, counsel. Brendan, continue.
Good morning, Mr. President. My name is Brandon Zhang, as introduced earlier. I am the counsel for appellants. I will make two main submissions. First, we submit that the anonymous email and anonymous witness statement is inadmissible. And second, we submit that my client, Mr. Antonio Fortuna, is not guilty of match fixing. I'll now turn to the first submission. There are strict conditions which must be met in order to submit anonymous evidence, and these conditions have not been met in the present case. In the 2019 CAS decision of Kareem Karamuddin versus FIFA at paragraph 129, the panel held that anonymous witness statements are subject to the following conditions: necessity, risk, verification of ID, and cross-examination. And at paragraph 133 to 135, the panel granted the appellant the chance to verify and cross-examine the anonymous witnesses with a voice scrambler, and there was also a CAS counsel present physically at the location to verify their identities. In the 2009 CAS decision of FK Pobeda versus UEFA at paragraph 14 to 16, the witnesses were exposed to threats, insults, pressure, and intimidation, yet the panel still held that the appellant had the right to cross-examine, and also a CAS counsel was present to verify their identities. Turning to the facts of our case, if I may direct Mr. President's attention to page 32 of the online PDF or the hard copy as well.
Hang on. Page 32, huh?
Yes, Mr. President, at paragraph 5.
Go on, go on. Thank you, go on.
Thank you, Mr. President. Here it states, my identity can never be revealed. Mr. President, this is fatal. The witness refuses cross-examination, even though the panel offers the audio-visual protection system through a voice scrambler to conceal the identity of the witness. Now, this poses a problem for my client because my client does not have the opportunity to cross-examine and find out what these specific statements were and how they came to be. And at paragraph 6, this is double hearsay. This is a witness who refuses to be ID'd before the court, who merely heard of rumors that the appellant's father was involved with a criminal organization. And therefore, these are rumors that are 2 layers removed. And moreover, the source and degree of the threat, we argue, is not as serious as, for example, other types of organized crimes, say, for example, drug trafficking, where the risk of retaliation is much greater. And therefore, we submit that Exhibit 2, the witness statement, should not be admissible. And in regards to Exhibit 3, the anonymous email, in Karamuddin versus FIFA at paragraph 188, the panel rejected WhatsApp messages, even though it contained a name attached, because appellant had not verified its authenticity. And
So the
therefore,
issue, counsel, Brendan, is that it's not an issue of whether it's on the format of the documentation. is the authenticity, isn't it? That was the core of the decision in the case. So in this case, this email seems to be authentic in my view. What is your comment?
Thank you, Mr. President. The email came from a burner account. And according to the clarifications of the record, the burner account has not been verified. And on those bases, we submit that it should not be admitted, and even if admitted, carries little evidential weight. Unless I may be of further assistance on
Continue. Next one. Continue.
I'll now turn to the second submission, Mr. President. We submit that my client is not guilty of match fixing for three reasons. First, the evidence does not meet the threshold of comfortable satisfaction. Second, the Genius betting report itself does not link my client to match fixing. And third, the respondent has not proved on balance, on comfortable satisfaction, that there was any links to his father.
Go on.
In the 2017 CAS decision, Olegs versus Pinkovsky versus LFF at paragraph 84, the panel held that the betting fraud systems report by itself does not constitute match fixing. And in the 2019 CAS decision of Ofusu versus LFF at paragraph 109, at paragraph 102, sorry, Mr. President, panel held that intelligence reports only focus on specific betting patterns and that it does not attribute it to any players.
Mm.
In the present case, we submit, turning to the facts of the case, that my client has not been established of being connected. There are three goals. In two of the goals that were scored, the second and third goal, there was held to be no performance errors on those two goals. And the third goal was scored, due to Santiago's injury, and this led to the goal being scored. And as well, in the performance section, there are minutes of interest, specifically at minute 11, minute 61, and minute 82. Now, in these minutes, for example, at 82, Paul is the one kicking the ball attempting to kick his ball into his own net. For your clarification there, this would be on page 15.
Yep,
Mr.
go on.
President.
Go
So
on.
Paul here is kicking the ball into his own net, and it was my client at the very bottom of the line, the page, who saves the goal. And therefore, we submit that there are other players who may potentially be involved, because we don't dispute the match betting allegations. There seems to be suspicious betting activities.
Yes, exactly. Because the red warning is quite significant. So when we look at the report by Genius Sports, it is quite obvious that there is a correlation between what is happening in the betting online and what your client was involved in. So how do you explain that coincidence? It's too coincidental, isn't it, Counsel?
Yes,
Go
Mr.
on, try.
Yes, Mr. President. Now, in in the Olegs Penkovsky versus LLF case, the panel held that there are other players who may be involved in match fixing, and more than one on the field. And on those bases, it was held that because there was other players involved, that did not necessarily could be those actions attributed to the appellant. And for example, at minute 11, Royce miscontrols a short routine pass. At minute 61, Reyes attempts a back heel ball, and the ball ended rolling out of play for an Iridonian goal kick. These suspicious activities indicate that there were players such as Paul and Reyes and Royce on both teams those players may possibly have been involved in match fixing. And this goes back to the evidence, the anonymous witness statement. If the anonymous witness statement was made by Paul, who was attempting to kick the ball into his own net, then this would be very detrimental to my client, who we submit is not guilty of match fixing. On these bases, I conclude my submissions unless there are further questions from the president. Mr.
Yeah, thank you, Brennan. Can I hear from the respondents, please?
Thank you.
So for the four of you, when you moot this, right? Are you going to moot fix all the way as an appellant, or fix all the way or as a respondent, or are you going to be forced to flip and switch round by round? How does it work in Madrid?
For online rounds, we have been allocated 2 appellant, 1 respondent, and
I see.
subject to the last 16, we are not too sure on that order yet. Yeah.
I see. Okay. So you look. So who's among the four of you who is stuck doing the appellant?
We actually haven't been allocated yet either by our coach.
I see. I see.
Yeah.
Your coach is a law lecturer or a moot coach or a lawyer?
He's a moot coach and a practitioner as well.
I see. Who is it he or she?
It's a he.
Who is it?
Derek Fan, if you know who that is.
Derek Fun. Which firm is he from?
Shuklin currently.
Derickfan.
Hmm.
I think I've seen his name on LinkedIn, I think. Yeah. Anyway, proceed. Let's wrap it up so that you all can go off and the three of you dating anybody? Any girlfriend or boyfriend?
Yes, Mr. President.
Then don't you think you want to go and see your other half instead of seeing me?
Actually, we have a second PR in the afternoon as well with
Oh my God, who's the coach for the afternoon?
one of our SMU alumni.
I see. Very good, you guys. Hardworking. I really want to do well. Make me very inspired to see the three of you doing this. Yeah. Okay. I'm really proud, Yeah. Looking at the three of you, not bad, these three boys doing this. Well done. On a side note, when I first started my career, there was no YouTube, no coaches. I was given a file and I had to do a trial. First time in my life to do a trial. You know what I had to do, guys? I took that file and I went from one courtroom to another in KL courts to see which court has a trial. And then I walked in, there was a trial. And it was true enough, a personal injury. In the early days, I purposely did personal injury because that was the best place to do trial. Even though everyone looked down on lawyers who do personal injury, I said I didn't care. I want to learn. So I walked into a trial, sat down at the back, take notes. And the judge was looking at me. He says, young man, what are you doing here? Are you a reporter? And I stood up and said, of course, in lower courts, we call him Tuan, which is sir. I said, Tuan, I'm Tuan Hakim. I'm so sorry. I'm actually a young lawyer and I have a trial next week in Malacca. And I've never done a trial before. So I want to learn. Then the judge said, oh, very okay, good, come and sit down. And then we end up having a tuition while he was conducting a real trial. So I think what the three of you are doing bring me back that kind of memories. But it helps, what you're doing. I think you are getting ready and getting your skin, make it thicker, so they get ready for your debates. But I must tell you, some of these judges, especially the European judges, can be quite nasty, So you got to be very careful with the way you talk, and then the words you use. Okay, shoot. All yours, guys.
Okay. Good morning, Mr. President. I'm Ramesh Kanna, and I'll act for the respondent, FIFA, together with my co-counsel, Mr. Seah. I will first talk about the first 2 issues for 10 minutes, and my co-counsel will bring you through the last 2 issues for 10 minutes, We respectfully reserve 1 minute for rebuttals.
Yep, go ahead.
Mr. President, opposing counsel ended off by stating that fairness is achieved when a calibrated approach is taken, insinuating that if they were to be denied the first two issues, then a formalistic, rigid approach had been taken and that justice had not been served. In my submissions, I will explain precisely why, even if we take the calibrated approach that opposing counsel speaks of, they still do not fall within the exceptions that they seek to rely on. In this regard, I make two submissions. Firstly, the statement of appeal is not admissible. And secondly, the refusal to hand over his phone was unlawful by Mr. Fortuna. Now, with regard to the first submission, we agree with the opposing counsel that indeed the statement of appeal had not been submitted within time. And the heart of the contention for this issue relies on whether the remedy of reinstatement can be provided. Now, when we look at reinstatement, opposing counsel himself concedes that cases such as the 2016 SFT claimant and FIFA decision have shown that reinstatement is a threshold. Reinstatement is a remedy that is not easily provided. Moreover, the case that opposing counsel himself relies on, which is the 2019 CAS decision of PFC and UEFA, itself acknowledges that allowing for reinstatement does infringe upon equal treatment of parties and legal certainty. Now, Mr. President, my purpose in explaining this is not to pitch my case so high as to say that reinstatement should not be allowed at all, but rather to paint a picture that it is indeed extremely exceptional. Now, with regard to this, the two-element test is not met in the present case. I note that Mr. President had questioned opposing counsel earlier on what is the standard of what is the standard of proof that is required by opposing counsel. Mr. President, this is precisely the most important matter at discussion, because the evidence that opposing counsel relies on to prove these two elements is a mere screenshot. If I could refer, Mr. President, to page 52 of the record, 52 of the PDF record.
Yes, go on, go on.
At Exhibit 9. Is Mr. President with me?
Yeah, proceed,
It
proceed.
shows the screenshot that opposing counsel relies on. And in this screenshot, the IT service provider himself states that the issue is believed to have been resolved. And yet, opposing counsel says that they required the next 2 days to resolve the issues and send out the reinstatement request. Might I note, it was not a situation where they had immediately stated the reinstatement request. They had first inquired with CAS to even ask if they had received the email. Now, this is far in breach of the due diligence standards that is required, because as per the screenshot that they themselves provide, they should have been able to confirm that CAS had receipt of the
But
statement.
counsel, let me get this right factually. How many days delay did the appellant incur here? 1 day, 2 days?
2 days, Mr. President.
2 days, right? So what is the prejudicial impact on FIFA? I'm inclined to grant them the extension because I think justice must allow them to at least be heard. Tell me, what is the prejudicial impact on FIFA for this 2 days delay?
The prejudicial effect, Mr. President, would be that they had an extra 2 days, which was unwarranted for them to make their statement of appeal. This extra time goes against the principle of equal treatment for the parties because FIFA respectfully has remained within the boundaries of whatever time that is to be abided by.
But counsel, the earlier learned counsel for the appellant persuaded me that the timeline actually had fallen on a Sunday. And we all know that we don't work on a Sunday. We are all in church, even though I'm a Buddhist, but never mind. We're all in church. So how would that be the expectation on the appellant to file something on a Sunday would not be easily the other way around, would not be unfair to the appellant?
I understand the concern, Mr. President. To clarify, we're not pitching our case so high as to say that they have to file the statement of appeal on the Sunday itself. However, what we're stating is that waiting until Tuesday was definitely not prompt, given that they had known the occurrence had ended by Sunday itself. Thus, maybe if they had filed it on Monday, there would be a case to make. However, I also understand that the underlying concern of this whole issue is what is the level of granularity that the panel should take. And with this regard, the panel has to be comfortably satisfied that whatever delay that was taken was necessary. And in this case, a 2-day delay had been taken when the IT service provider has already stated that they believe the issue to be resolved. Thus, opposing counsel has to comfortably satisfy you that against the own evidence they provide, that the issue had not been resolved. And we
All right, hold on, move on.
this has not been met. Moving on to the second issue, Mr. President, with regard to the refusal to hand over the appellant's phone, opposing counsel relies on Article 6 of the ECHR. We do not contend on the applicability of Article 6. We do agree that it applies. And we also agree that as per CAS jurisprudence, the requisite standard is that there must be a clear and imminent danger that whatever information that is being shared within the FIFA trial would be sent over to the public prosecutor. Now, in this particular case, this threshold has not been met. Opposing counsel cites the fact that the anonymous email had been sent over to the public prosecutor's office and that this shows they are collaborating. Now, we do not contend this. However, the nature of evidence, the anonymous email, is far different compared to the phone that is being handed over by the appellant. As opposing counsel themselves have stated, the anonymous email is not metadata verified. Thus, its probative value is extremely low. And in this scenario, FIFA had to send it over to the public prosecutor's office to get it authenticated and to understand what the value of this evidence is. And there's precedent to support this sort of collaboration. If we see
But counsel, aren't you a football organization?
Yes, Mr. President.
So the submissions that you are speaking on behalf of your client over the last 3 minutes, you sound like you are in a police authority. Isn't that a little over the line? At the end of the day, FIFA is only a football organizer. Your job is to organize football tournaments, get players to play, develop young talents, that kind of stuff. How do you justify the power to do what you just did?
I understand that there are two questions in that, Mr. President. So firstly, the power that FIFA has to request for information is founded on Article 12, subsection 3 of the FIFA Disciplinary Code. Thus, it is legally within FIFA's rights to request for any information. But I also understand that beyond the legal matrix, Mr. President also wonders why FIFA, a sporting organization, is so interested in disciplinary measures. This is because beyond organizing football games, FIFA is actually housing a multi-billion-dollar industry where sports betting and other activities occur. And all of these activities depend upon the integrity of FIFA's games. Thus, if the integrity is breached, there's huge monetary losses made by all the other stakeholders that are present. Thus, it is well within FIFA's rights and interests to ensure that their games are treated fairly and the integrity is maintained.
I think there's a fair comment to maintain integrity in the sports, but does it include things like snatching mobile phones away, or that is encroaching into a person's private liberty? I think FIFA is on dangerous grounds, and we are in Europe. ECHR will always prevail over FIFA rules. What is your comment on that, counsel?
Understand, Mr. President, and your intuitions are well founded in that the right to privacy is actually founded in Article 8 of the ECHR. Now, with regard to this, FIFA does not require the appellant to hand over his entire phone. FIFA was very cognizant of this issue, and that is why in their second request, they had actually provided the appellant with the autonomy to decide what evidence or what data on their phone they would wish to provide. Thus, this falls far below the threshold required to activate the Article 8 right, because instead of even requiring any set piece of evidence, also, Mr. President, I note that my time has elapsed. Could I request for...
Can you wrap it up? I'm taking notes of your comments. Just wrap it up.
Okay. given the fact that the appellant was given the autonomy to decide what data they wish to provide, it it was well within their ability to just provide evidence that does not encroach upon their privacy and does not self-incriminate them in the public prosecutor's proceedings. However, they chose not to do this, and they have decided to not provide any evidence at all, and did not also ask FIFA to qualify what they meant by relevant. Thus, this is utter lack of cooperation towards investigative efforts. And that is why we argue that an adverse inference can be made against the appellant, because the two-limb test is indeed met. Since Article 8 and Article 6 have not been invoked, it was well within appellant's control to provide this evidence. And secondly, this evidence is highly probative, because as we go into the last two issues, Mr. President would realize that if we had access to the contents of the appellant's phone, we would be able to determine what the conversation and the nature of relationship appellant has with his father to determine if match manipulation had indeed occurred. Thus, this would actually be exculpatory evidence for the appellant if we take the appellant's case to be true.
Yep.
Yet they did not.
Continue. Next, counsel.
Thank you, Mr. President. As earlier introduced, my name is Austin Seah, and I'll be addressing the remaining two issues on appeal for 10 minutes. Now, turning to the third issue, in the same vein, we do agree that Article 6 is applicable, and the 2019 case decision of Karimuddin did note that there are three elements to be met if anonymous evidence was to be admitted. And these three elements are: firstly, there must be a good reason for anonymity; secondly, whether the evidence in itself is sole or decisive; and lastly, whether there are counterbalancing safeguards in the event of no physical cross-examination. Now, turning to the first element, I do know that counsel for the appellant has claimed that there was no real threat in our case. However, in Karimuddin itself, the court noted that there's no need for actual proof of a real threat. Rather, a risk is sufficient. And in our case, we do note that it involves alleged criminal networks with an ongoing police investigation. If I may now turn Mr. President's attention to page 32, paragraph 6 of the record, which shows the anonymous witness statement itself.
Okay, go on. Go on.
It is noted that the appellant's father could have friends in the criminal world. Now, taking in consideration that this is a match manipulation context, with individuals in power manipulating the matches in the background with possible criminal ties, it can easily be argued that the witness himself, at the very least, possibly may face criminal reprise, such that he may get hurt, or if his identity was to be revealed, that he could be exposed. And ultimately, we argue that this is sufficient of a real risk, rather it is not an actual threat. And now, turning to the second element, we are not relying on this witness statement or email in isolation. And as crucially noted by Mr. President in his question just now, we do agree that the email in itself is authentic. And the appellant has claimed that the email came from a burner account, but on the facts, that has not been substantiated or stated anywhere. And in regards to the idea of relying on the evidence in itself in isolation, we do note the 2009 decision of F.K. Pobeda, which noted that a decisive question as to whether anonymous evidence can be relied upon is whether the evidence in itself is corroborative rather than decisive. Now, at this juncture, we are not alleging that this anonymous evidence in itself can prove a claim of match manipulation. Rather, when we take it together with the Genius report, it does provide a set of contemporaneous evidence that supports what was noted in the report. If I may now turn Mr. President's attention to page 33 of the record, at paragraphs 9 and 10.
Go on.
It is noted that a witness recounts the incident where the appellant told his father to stop pressuring him, and then a couple of minutes later, stormed out. Well, this actually ties in with anomalous betting that occurred 12 hours before the match. And if at this juncture, if I may turn Mr. President's attention again to page 12 of the PDF, 6 paragraphs under the title header.
Go on.
It is noted that 12 hours before the match itself, which is around the same timeline that this phone call took place, betting support for the opposing team, Combatland, took up pace. And it's crucial to note that Combatland was never going to win in this case, because based on previous match statistics, it was at the lowest of this group, and Iridonia, in comparison, had a far superior team lineup. And therefore, in light of these very facts, we can tie a claim of possible match manipulation of the fact that a phone call took place at the exact same juncture where betting support for the opposing team had picked up. And unless I may be of further assistance on the third issue, I'll now move on to the fourth issue on match manipulation.
You see, the comments and statement counsel from Mr. Antonio, he has explained that he himself was devastated by the loss. He seems to have explained that they know that they lost, but it was a sporting defeat as compared to a manipulative defeat. Yeah, of course, it's just a statement written from a man who is now being charged or being questioned, but it seems very sincere to me. He was also very willing to share of his relationship with his father. So won't FIFA take into account the possibility that, number one, the betting was really purely coincidental? It happens. We've seen before the biggest results. I recall one World Cup football recently where the host nation, the so-called lower football ranking nation of Saudi Arabia defeated Argentina in the opening game. And then the same Argentinian team went on to win the World Cup. So if that day people had placed a bet that Saudi Arabia was going to win, then people like Lionel Messi would have been found guilty for sport betting and they would have not won the World Cup. So won't FIFA take into account the possibility that this was really coincidental and the player has been very sincere in explaining their position?
I understand, Mr. President, and I do understand that your question also goes towards the final issue of match manipulation.
Yeah, it's connected to the next issue, but go on together.
Certainly. On the issue of sincerity, it is also to be noted that this witness statement that Mr. Fortuna made was carefully crafted by himself and his legal counsel. So with regards to sincerity itself, it could be possibly said that his counsel is helping him couch his case in certain terms that would allow FIFA to find compassion in the current situation that he faces. And therefore, based on the very fact that Mr. President had also noted that this could be just a mere assertion of the appellant trying to exculpate himself from any liability, we submit that little to no weight should be given to the witness statement. And to answer Mr. President's second question on the idea of a possible coincidental loss, we have to analyze the actions of the appellant himself. And now, as noted by counsel for the appellant, there were junctures in a game where it wasn't solely just the appellant making mistakes. Rather, it was his teammates as well. However, this actually does not explain any of the betting anomalies that took place prior to the match. If I may turn Mr. President's attention to PDF page 14 itself.
Page 14, hang on. Go on.
At the header of conclusion under pre-match betting.
Go on.
It is crucially noted that even before any of the players stepped onto the field, there was unjustifiable betting support. And now, considering the context of the match where Combatland was noted to be had a lower chance of winning, even before any of the players stepped onto the match, there was already betting support for Combatland. And therefore, we submit there's no corroboration between the fact that the players played poorly, resulting in the fact that there was betting support for the other team. And as crucially noted by Mr. President, this match itself has been awarded a red grading, which is high proof of a possible match manipulation in our case. Now, turning to the idea that there must be an indirect involvement between the appellant and his father himself, we turn now to the issue of the phone call tying in with the betting anomaly as noted by my co-counsel earlier. And
The so-called heated phone call.
Yes, Mr. President.
Mm.
Now, we do acknowledge that if we take the phone call in its by itself, we do agree that multiple interpretations can be made as to what the phone call entailed. But taking it together with the betting anomaly set out in the Genius report, which is the precise manner that this court must take in terms of ascertaining if match manipulation can be made out, we do submit that there's a corroboration and hence there's a sufficient link between the appellant and his father. And I do note that if Mr. President is still uncomfortable with this inference, I turn now to my co-counsel submission of adverse inference. Because at this juncture, the appellant himself could have either submitted his mobile phone or provided clarifications in his witness statement as to the specific nature of the phone call to dispel any claims that the respondent may have or assumptions that the respondent may have as to the nature of the phone calls. However, as noted in the witness statement itself, he refuses to provide any evidence or any assertions as to what the phone call actually entailed.
I just wonder, counsel, whether the concept of adverse inference applies in arbitration. This is an arbitration matter. Evidences are free and easy to be submitted. It is for us to be comfortably satisfied. The issues of adverse inference are usually connected to the objectivity of the case. So in a normal common law case or any of these civil law cases, the standards are all objective. Whether the objective standard, a reasonable man will decide in a certain way. So that's why there's an adverse inference against a person for not contributing any evidence. But here being on a comfortable satisfaction, I do not know whether there's any value in that submissions your earlier counsel mentioned on adverse inference.
Certainly, Mr. President, and I do know your question has two parts and I will address them in turn. So with regards to the panel's power to draw an adverse inference, this can be founded in the International Bar Association rules, Article 9, subsection 6. And in respect to the applicability in the cases of CAS precedents, the 2019 CAS decision of Quintana and Wider Athletic Club had indeed cited this specific article for adverse inference in a case where they also acknowledged that objectivity was key if adverse inference can be drawn. And turning to Mr. President's second question on objectivity in our case, we are relying on the fact that the appellant himself could have clarified, and the objective evidence that goes towards that is in his very witness statement. Now, the only reason why adverse inference cannot be drawn is if there was a good reason for why the appellant himself refuses to hand over his mobile phone, and this was noted in Article 9, subsection 6 of the IBA rules itself. However, instead of providing any explanation as to why he refuses to hand over his mobile phone or any explanation as to the phone call itself, he keeps silent and instead describes a more heated discussion with his father. Actually, no, he didn't even describe a heated discussion with his father. Rather, he just described his relationship, carefully skirting the issue of what the phone call may entail itself. And therefore, we submit that an adverse inference can ultimately be drawn.
Well, I'll decide that later. But yeah, proceed. Can you wrap it up and finish it off? I would like to move on.
Certainly, Mr. President. And actually, at the juncture, I have concluded my submissions on the fact that there was an indirect claim between the appellant and his father, and this is sufficient under Article 20 of the FDC for a claim of match manipulation to be made out. This concludes my submissions, if I may be of no further assistance.
Okay.